we've got what I think will be one of the most important topics we've covered on the Trade Ahead series: U.S. extraterritorial measures, U.S. export controls, and their impacts on Canada. Given that 77% of Canadian exports in 2022 went to the U.S., 88 to 90% for Alberta, changes impacting our ability to sell products into the U.S. and to import inputs into manufacturing products has a huge impact on Canada. So very quickly, for those who weren't here yesterday, the Trade Ahead series arose with COVID. We learned many lessons from that era, including how to use webinars and Zoom. But one of the other things we learned was that we were getting hit with one unexpected shock after another on the trade front. But those of us that were analysts or are analysts that are mired deep into the weeds of trade policy, following obscure WTO meetings and reading articles in the Thai newspaper about impending trade issues, we felt that we could do a better job of bringing changes that we saw coming to the general public that was more focused on the end of the quarter, the next transaction. Didn't have time to do the deeper analysis. So that's what we're doing with the series. And once again, we're delighted to have the support of Export Development Canada, their sponsorship for this event, as well as our provincial trade partners, whom I'll introduce in the second half. Very briefly, on extraterritoriality, this is an issue that we in Canada, and certainly we in the West, have encountered with the U.S. in the past. 1950s, Canada decided not to adhere to the U.S. grain embargo, the wheat embargo against China during that country's worst famine. And as a result of not going along with the embargo, the Americans took action against Canada, banning the sale of grain excavators for loading ships, preventing grain ships from being fueled in Vancouver Harbor, Vancouver, British Columbia, not Vancouver, Canada. The Americans prevented ships in Vancouver from being fueled. And of course, in the 60s, we dealt, and the 70s, 90s, we dealt with the Americans over Helms-Burton, the U.S. series of laws designed to enforce an economic embargo against Cuba. We had incidents of Canadian business owners, executives being charged with crimes and having jail time assigned to them, and also to having Walmart Canada being told by the U.S. government via Walmart in Arkansas to remove products from Canadian shelves. So we've dealt with these issues in the past, but Cuba is not China, and the U.S. move to respond to China is much wider and potentially much more impactful for Canada. And indeed, as one of our guests mentioned, we've seen that with the recent announcement of TikTok and the ban on TikTok on Canadian government devices. So helping us work through these issues, we have two U.S. lawyers, one of whom served in the Obama administration on export controls. I'll bring them in. One will focus on issues with exporting to the U.S., and the other with the other side, imports and investments. So Kevin Wolf joins us in Washington, D.C. Kevin, I'm not going to do justice to your bio, so why don't you introduce yourself and get right into it?
Sure, happy to help. Thanks for asking. So I'm a partner in a DC law firm now, Aiken Gump. I do export controls and trade regulatory compliance and policy work. As mentioned, during the Obama administration, was the Assistant Secretary for Export Administration and shepherded a fairly fundamental change of the defense trade and other rules. So dual use in defense trade, and have been doing this now. I'm in my 30th year of export control related work. And with respect to Canada, one of the elements of the reform effort was to frankly remove almost all controls on trade to and from Canada, the US. On the dual use side, there are really only 5 very limited exceptions involving some surveillance items and a particular kind of satellite, where under the commerce regulations, a license is really to or from Canada required under US law. And with the ITAR, you have a unique status as under a Canadian exemption that doesn't even exist for Australia and the UK or other close allies. although it does have some limitations and some complexity in its compliance. So for intra-US Canada trade, things are fairly stable and simple, and not much has changed. But that on the downside of that is it puts Canadian companies pretty much in the shoes of being a US company for purposes of trade compliance, given the extraterritorial application of US rules. And so US origin items that you would receive are always controlled. And then under the Canadian rules, under the commerce rules, there is a long history of asserting extraterritorial jurisdiction over non-US made items if they contain a certain percentage of controlled US content and are destined to particular countries. And then something called a direct product rule, which means that a non-US made item that's made directly from US technology is subject to US controls. And that goes back to the 1950s. Sorry, there's a fire truck outside. And this is the joys of no longer working from home. I put on a tie and there are fire trucks outside. But what's changing really since it really got started sort of at the end of my time in the Obama administration, and it really accelerated during the Trump administration, and the Biden team has continued and expanded it, is a fundamentally different thinking about the role and purpose and use of export controls, particularly with respect to China and Russia. And what I mean by that is that the classical export control system that Canada and the US and the other allies put in place at the end of the Cold War in the 1990s was a system that regulated the movement of items that had some identifiable relationship to the development, production, or use of either a weapon of mass destruction or a conventional military item. And these items, commodity, software, and technology, were identified on one of 4 multilateral regime lists that Canada and the US are both members of, as well as other close allies and partners. And the change with respect to China is, how does this classical system that's focused on items that have some direct relationship to weapons, how does that address the national security issues that have become sort of conventional Democrat, Republican administration and congressional wisdom of the broader than classical national security threat involving China's civil military fusion policies, which basically have a state policy, the use of commercial technologies to modernize its military, the use of commercial items for use in human rights abuses, such as mass surveillance and in connection with the Uyghur concentration camps, and then strategic economic dominance objectives of China, where it's artificially subsidizing its economy to the intended detriment of US, Canadian, and other allied country companies. And so the law was changed in 2018 that governed export controls, that basically required the Commerce Department, the agency that regulates export controls here, to identify emerging and foundational technologies that are essential to national security, but that are outside the scope of this classical regime construct. Now, none of those terms were defined by Congress. The mandate wasn't provided. It was just this new mission to go out there and do something on China. And the Trump administration, for all of its bluster and individual unilateral actions of adding entities like Huawei to the entity list, didn't announce a coherent vision, but it really started in October of 2020, an expansion of the extraterritorial jurisdictional reach of these regulations. And it started with something called an expanded foreign direct product rule that basically said, anything non-US made that is produced from US software technology that's on one of the control lists, or that is produced with US equipment, such as a test equipment or otherwise, and if it's destined to Huawei or one of its parties or otherwise involved, then that export, even from abroad, even from Canada, even from Korea, even if wholly non-US made with no US content and no US persons, if Huawei is involved and US software equipment was used to make it, it's all going to be caught subject to US licensing jurisdiction. And that dropped in August of 2020. And then the Biden administration expanded that rule considerably a year ago, really this month, in its response with the allies, including Canada, on Russia's continuing invasion of Ukraine, and expanded the reach of most foreign-made items of some sort if produced with US technology or tools, but it excluded from that foreign direct product rule allies such as Canada that adopted their own controls. So the extraterritorial reach of the foreign direct product rule on shipments from Canada, unlike with Huawei, didn't apply if Russia or Belarus were involved. And then in October of last year, as part of a broader strategic trade controls initiative of thinking more broadly about export controls, the Biden administration imposed controls on all of the inputs into the development of production in China of four things: semiconductor production equipment of any kind, advanced node semiconductors, whether logic, DRAM, or NAND, and all the inputs used to produce or develop them in China, including services by U.S. persons, whether individual employees or U.S. companies. Inputs into AI things of concern, principally graphic processing units, even if foreign made, that exceed a certain threshold. And then also inputs and services for production in China of supercomputers. Now, this was a US only control and specific only to China, but for you all and for anybody outside the US, the significant part, unlike the Russia rules, is that there wasn't a carve out with respect to shipments from allies of items produced or developed with US software technology or equipment of certain types, if there was knowledge that they were ultimately destined to China for use in producing or developing, for example, advanced node semiconductors. And then just literally Friday, in a rule that I've not really come to understand, that the foreign made items that are the types of items that would go into a unmanned aerial vehicle, if destined to Iran, even if wholly non-US made, become subject to US export controls. So the virtue and the vice of being a close partner is that you don't have really that many controls on bilateral trade, but to the extent you're doing anything with China these days, or with the carve out of Russia, that US laws can apply to Canadian origin commodity software and technology in the process for going through and deciding when those rules cover. I'll end here with sort of what's coming and then open it up for lots of questions as you like later. So this broader strategic objective that the US is leading is really administration policy. And it's going to be for the foreseeable future of not wanting to limit export controls to the more classical non-proliferation focused approach. And so basically anything involving the indigenous development of advanced node supercomputers or semiconductors or anything AI related or quantum computing related in China, the US government is going to be finding ways to block, even if there's no clear relationship to a weapon. And it's going to be doing so through the cooperation of allies that have producer nations, producer companies in those sectors. And so, for example, you've read about probably an apparent deal between the Japanese, the US, and the Dutch governments on imposing controls on advanced node semiconductor production equipment specific to China, because those are the three countries that are the primary manufacturers of such items. And what the US government is going to be doing with other allies, this is where Canada will be involved at some point, is going through and finding out who the countries are that are the key producers in the technologies of concern and asking if they will cooperate in this kind of a plurilateral arrangement. So, from a practitioner and a compliance perspective, particularly if you're doing anything involving China, the rules become quite complex and the extraterritorial application become quite complex. And to the extent there's anything involving Russia directly or indirectly, they're a little bit more straightforward, but they're fairly novel in their implementation, notwithstanding the carve out of the extraterritorial reach for shipments from Canada, because the Canadian government has imposed similar controls. So that's the history of the last 30 years and 30 weeks and 3 weeks and 3 days, literally, since these rules on Iran were published on Friday, in addition to more expanded Russia-specific rules. So I'll stop there, turn it over to Nelson, and be available for questions as you like.
Thanks, Kevin. That's quite sobering. The other point I guess I've heard you make before is that these rules can be implemented on a Friday to go into effect on a Monday, or even a Friday morning to go into effect at the end of the day, as with semiconductors. So,
yeah. What's actually worse than that? No, the more accurate way of saying it is they'll be published on a Monday and take effect the previous Friday. The Trump administration and the Biden team has continued something that I never did, which is to make rules effective upon their draft publication, and so they actually sort of kind of have a retroactive effect. No one's going to get in trouble for that, I suspect. But yeah, you're right. It's not only the pace of change, the timing of the change, and Friday afternoon rules are quite common. It's the complexity, it's the extraterritorial aspect, and it's the sort of non-classical thinking, because what national security means has a much more expansive concept now in the US than it used to. So this is an area for which practitioners, really need to pay close attention.
Wow. Okay, Nelson, over to you.
Thank you very much, Carlo. It's an honor to join you and Kevin today in this Trade Ahead webinar. Dorsey & Whitney, my law firm, of which I'm an attorney, has offices both in Toronto and Vancouver, and we've been serving Canadian clients on these US law matters for well over 3 decades. As Kevin just explained, most of the historical regulatory regimes in the United States have dealt with the export control side in this classical paradigm that Kevin just explained. And because of the very close defense cooperation that has existed between Canada and the United States for now well over 100 years, Canada has faced minimal or even no effective export control limitations. However, just as Kevin explained, that some of these rules are changing because the paradigm is changing to address these new strategic threats facing North America from China and Russia. So too is the environment on the flip side of the coin, which is the import side. And we're seeing now more and more legal regulation of imports coming in from other countries into the United States that are directed again toward Russia and China. And it'll be my job in the few minutes that I have today to go through some of those differences. The first sector I'll touch on has to do with the Canadian defense and aerospace industries and new US prohibitions on goods and inputs that go into such things. It's important to realize, as Kevin noted earlier, and as Carlo noted, the United States is Canada's largest trading partner, both for commercial, but as well for aerospace and military things. And indeed, over half of all of Canada's exports in the munitions space go into the United States. So I'm going to touch on 2 different legal changes that occurred over the last couple of years that Canadian companies should be aware of that participate in the defense and aerospace sector. First, in 2019, in the National Defense Authorization Act, Congress mandated something called Section 889. 889 now prohibits any government contractor or subcontractor from supplying the US Defense Department or any other part of the US government with either telecommunications or video surveillance equipment, systems, or services that are sourced from 6 specific companies. 5 of those are in China, including Huawei, ZTE, Hytera, Hangzhou, and Dahua, and then also 1 Russian company, AO Kaspersky Labs. So the Secretary of Defense under 889 is also authorized to name additional companies from time to time that are affiliated with either of the Chinese or Russian governments. So it's important, if you're participating in the defense space, to make sure that you monitor your supply chain and do not yourselves purchase goods and inputs from any of these listed companies, but also that your subcontractors are also admonished not to do that, because you will be held responsible by the US prime that is buying your products for supply to the US government. Moving ahead to 2021, in June of that year, President Biden issued something called Executive Order 14032. The primary purpose of that executive order was to bar Americans from buying the public securities of 59 listed Chinese companies that were deemed to be closely associated with the Chinese government, the Chinese military, the Chinese Communist Party. However, one provision of EO 14032 also named the Office of Foreign Assets Control, the sanctions body in the US government, with authority to promulgate a new sanctions list, which has the unwieldy name of the non-specially designated nationals Chinese military industrial complex companies list. This list now has well over 200 Chinese companies on it. In addition, in December of 2021, OFAC, this agency that administers the list, named 9 more Chinese companies to the original list for supplying surveillance and biometric technology to the security officials in Xinjiang province, which has been used to oppress and deprive Uyghurs in the Xinjiang region of their human rights. So the takeaway message on this Section 889 is that while there is no legal barrier at the moment, no formal legal bar prohibiting inputs from any of these companies, I think a Canadian defense contractor would be well advised to make sure you're aware that your companies and your subcontractors are combing your supply chains to make sure none of these listed companies that are US government has formally designated as being subject to Chinese Communist Party control or affiliation are in your supply chains, lest you be deeply embarrassed the next time your customers do an audit of your supply chain. Turning to the information and IT, ICT industries, in March of 2021, the US Department of Commerce adopted for the first time new so-called ICTS, or Information Communication Technology Services rules, barring hardware, software, or services, including cloud computing services that have anything to do with data. And the definitions are very, very broad about what constitutes transactions in this space. But the barred prohibitions or barred transactions affect specific named foreign adversary countries. These include China, including Hong Kong, Cuba, Iran, North Korea, Russia, and Venezuela. These rules affect 6 critical categories of ICTS goods and services: critical infrastructure, network infrastructure, sensitive personal data of US persons, widely distributed ICTS hardware, which is a bureaucratic way of saying cell phones, software for widely distributed ICTS apps, and emerging technologies such as AI, machine learning, UAV, robotics, autonomous systems, quantum computing, and the like. So most Canadian IT suppliers would not go to places such as Iran or North Korea, but historically, Canadian companies have traded more freely with Russia, with Cuba, with Venezuela. And so it's important not only for your own companies, once again, but also for your subcontractors to know about these rules. And these rules have significant financial bite. The maximum civil penalty for violating these rules is more than $300,000, or double the amount of the transaction in value on the civil side. And the criminal penalties are more than $1 million, 20 years in prison, or both. So these things are really quite serious. On the manufacturing side, it's important now to focus again on this issue that Kevin and I have both talked about, which is the oppression of the Uyghurs in Xinjiang province in the northwest of China. Historically, the United States had a law that's been on the books for nearly a century, barring the importation of goods that are made in whole or in part with child, convict, or forced labor. However, the US Congress was unhappy with the case-by-case rule being applied by the Customs and Border Protection Force, because CBP bore the burden of proof in all of those proceedings, and so therefore often did not have enough information to bring an effective action to block imports of goods that were suspected of having been made with, say, forced labor. However, in 2021, US Congress passed the Uyghur Forced Labor Prevention Act, which adopted a reversal of the rule. And so under this law, there is a rebuttable presumption that all goods originating in whole or in part from Xinjiang have been made with forced labor. And so the importer then bears the burden of proof to show they were not made with forced labor, which puts an extreme premium on due diligence about the supply chain, all the way down to the raw materials used in making your goods. One of the problems with doing the due diligence to perfect that documentation to defend your supply chain is that the security officials in Xinjiang have generally prohibited any third-party independent auditors from going into Xinjiang to do the monitoring and inspections at factory work sites or farms. So it makes it very difficult to produce the documentation that CBP will demand. Why is this important for Canadian companies? Because China can affect so many goods that we often take for granted. For instance, China is the world's #1 producer of cotton, and Xinjiang produces 90% of China's cotton. China is the world's #1 producer of tomatoes and produces by itself 40% of the tomato paste in the world. So your pizza eaten in Calgary or Winnipeg may be made with tomato paste that was sourced in China. China is the #1 producer of polysilicon, and almost all of that polysilicon comes from Xinjiang province, which is necessary for making solar panels and semiconductors all over the world. So it's really, really critical with these new rules aimed at these forced labor prevention concerns for Canadian producers to monitor their supply chains and know where they're buying their goods. Last but not least, very recently, President Biden won over President Trump. Back in March of 2018, President Trump added a 10% ad valorem tariff on foreign-made aluminum. And then fortunately, both Mexico and Canada received exemptions in that imposition of new tariffs. However, last week, President Biden on February 24th announced that there will now be a 200% tariff on aluminum that is made, that is cast or smelted in Russia. In the order announcing these new rules, that tariff will apply to primary aluminum sourced from Russia that goes into any third country aluminum products made with Russian aluminum. And so it's important, once again, for Canadian producers that use aluminum and that import aluminum to make sure that you understand where that aluminum came from and whether any of it is sourced from Russia. Fortunately, according to trade data, Canada only imported about $35 million worth of Russian aluminum in 2021, and that fell down to 12 million in 2022 because of sanctions. But nonetheless, there's still some Russian aluminum floating around. And given the political pressure in the United States against Russia right now, it would be very, very imprudent to source aluminum or to allow your goods to be characterized as being built from or made from Russian aluminum if you intend to continue serving the US market. Finally, this provision, like the ones that Kevin described a moment ago, also allows other countries to adopt similar tariffs, in which case they will be exempted from this 200% rule. So it remains to be seen whether Ottawa will go ahead and do something like this to make a parallel imposition of punitive tariffs against Russian aluminum. Given the low volume of imports from Russia, it would not take much for Canada to move to take advantage of that exemption in the order. So the three bottom line takeaways here are Canadian companies that export to the United States do have to be vigilant in their own supply chains about embedding inputs that rely on producers in China and in Russia. They have to be conscious of the nationality, in particular, of the providers in those supply chains, so they can then do further due diligence to be sure that they're keeping an eye on these exploding, mushrooming sanctions lists that the US government is publishing. And finally, the idea of this extraterritorial reach needs to be taken into account as you do procurement for exports to the US market. And so with that, I will stop and we can begin our question and answer, Carlo, anytime you're ready.
Well, thank you very much, Kevin. Thank you very much, Nelson. And Nelson, to your point, with the Xinjiang rules, it's not just buying goods from companies in that province, it's the potential of buying goods from companies in other parts of China that are using those products, or potentially goods in neighboring countries that are using those products.
Third countries, it could be, for instance, cotton thread could be exported to make textiles in Malaysia or the Republic of South Africa and then sent into Canada. But if it's traceable back to Xinjiang, then those goods, when they arrive at a port of entry in the United States, will be subject to this law. And as of 3 months ago, over 1,000 shipments with valued at approximately $250 million have already been stopped by CBP using this new law.
Wow. Okay. That's certainly plenty on the plate for us to think about. So let's bring in our provincial representatives and what we do with Trade Ahead to drive the conversation to local relevancy for us in Western Canada. We invite our partners from trade support agencies across the prairies to join us. We've tried for 2 years to get Vancouver and BC on board. We'll keep trying, but no luck so far. So starting, we'll go east to west again. We have Andre Bryn from the World Trade Center in Winnipeg. We have Chris Decker from the Saskatchewan Trade Export Partnership. Up north, we have Manisha Arora from Edmonton Global, and we have Patrick Madarin from Calgary Economic Development. And joining as a special guest, given the topic matter today, we have Sam Woods, the president of Jury International, one of the, if not the largest customs broker in Western Canada, and someone who deals every day with getting goods back and forth across the border. So yesterday, Manisha, you went last. So we're going to have you go first today. Chris, you went first yesterday, so you'll close out the round. So Manisha, Patrick, Andre, Sam, and then Chris for the first round. So Manisha.
Thank you, Carlo, and thank you, Nelson and Kevin. That the explanation is much needed because it seems really complex. And I guess my question is, when I was hearing about this, is Nelson, you said that Canadian companies now have to be super vigilant on who their providers are going into the US market. What resources do they have to navigate this whole system now? So, whether that be organizations here, the Canadian consulate, how do they go in with some confidence that they're doing the right thing with some sort of back checking?
Well, there are conventionally companies that are concerned about US sanctions lists rely either on two means of keeping abreast of these developments. One is to use the US Department of Commerce export.gov search tool, which is free, and it is current, and it covers all of the US sanctions lists, including the agency that Kevin used to head, the Bureau of Industry and Security, as well as the Office of Foreign Assets Control and other agencies across the US government. This consolidated screening tool or screening list CSL tool is intended to afford all American companies and indeed all Canadian companies and other companies in the world to be aware of the US sanctions programs. The tool has some limitations in that it is only the US lists that are in this database, and it doesn't store any search results. So any company that wants to defend itself of having done due diligence at the moment it made a purchasing decision has to somehow manually create a PDF or a printout in hard copy and then store it and then be able to find that search result, months or years later. There are also many commercial tools, several of which, by the way, happen to be Canadian in origin, that are available, such as Visual Compliance, which I'll put in a shameless plug for, even though I have no affiliation with that company, but it is a very widely used tool. And it has several features that are advantageous to exporters. First, it covers many more lists. It includes the Canadian list, the UK list, the Australian list, the EU list, and other sources. So it gives you way more visibility into concerns around the world about sanctioned entities. Second, it has an automatic data storage system, so it logs when you did a search and it makes it easy to retrieve the search result. And it has an automatic alert feature so that once you search somebody and you qualified, say, a supplier or a customer, and if that name pops up on a sanctions list later, you get an automatic alert that tells you either one of your customers is in trouble or one of your suppliers is in trouble. And so it gives you that automatic sense of awareness of what's going on out there. Those features are what you pay for in a commercial tool that you don't get in the free tool. But that's probably, the best do-it-yourself in-house avenue of compliance is to defend yourself with one of these tools.
Any thoughts,
Kevin, you might have some other thoughts, but that's my sort of practice tip.
No, great summary.
Okay, let's go over. I think I said Sam. I think I was going to do you next, and then go over to Patrick.
Sure. Can you hear me okay? All right, perfect. Well, thank you for inviting me to ask a couple questions here. This is very, very interesting to me and the clients I work with. We're not the biggest customs broker in Western Canada, but we do work with a lot of small and medium-sized importers and exporters. So my question is around the practicality of the application of some of these rules. A story comes to mind. I remember when Trump put the original 25% across the board duty on Chinese goods. I was hearing stories of companies buying products from Vietnam and then finding out that the CBP had gone into the factory in Vietnam and there was a bunch of boxes labeled made in China. And in the factory, they were just changing the labels and calling them made in Vietnam. So I guess as an importer, what type of diligence can you do? I mean, you can't trace every piece of thread back to where it originally came from. And people are creative and companies are creative, and China has no problem trying to figure out how to skirt the rules. So what would you do as an importer to do for that type of stuff? And then on the export side, a lot of times companies will sell to a third-party country. They have an end-use certificate stating, I will never use it for anything other than using it in, I don't know, in Cambodia, and then it ends up in China. I mean, this stuff, I haven't seen it. I've heard lots of stories of this. Just some comments and ideas on how to approach that and what the ideas are there.
Nelson, can you answer the first question? I'm not able to.
Yes.
Okay.
You want to go ahead and do the second question?
Oh, all right, I'll do the second question. So the rules that I referred to, these new foreign direct product extraterritorial rules, if a transaction that's covered somehow involves Huawei or one of the many Huawei companies, or somehow involves the development or production of advanced node semiconductors in China, or involves a U.S. origin item for use by a military end user or military end use in China, They all have knowledge requirements in that there isn't a strict liability concept that if you're a Canadian company shipping something and you've got a end user search or other information indicating that it's for a benign application or not in China, then absent some red flag, absent some suspicion that the information you got was not correct, a licensing requirement doesn't kick in. And so what companies do, freight forwarders or companies, is have some method of ensuring and aggregating within the company the knowledge of who the end use and what the end user is. And they generally do it through a combination of, and there's no one magic rule. These are all risk assessments that different entities take through a combination of certifications from the parties, which can be very aggressive in terms of questionnaires and very passive in terms of understandings that are part of purchase orders. A next layer is due diligence in terms of inquiring for publicly available information about whether the parties involved are sanctioned or otherwise problematic. So it really, the answer is it depends, but at least as a legal matter for the rules that I was referring to, they don't impose strict liability for a Canadian doing something where all the information indicated that it was for benign, non-prescribed end user. The legal exposure kicks in if there's knowledge, and that becomes then a fact question when there's investigation about what the company knew, because under the US and I think also under the Canadian system, the knowledge of each one of your individual employees is the knowledge of the company. It's imputed upward, and the knowledge of the company, the employees together, is aggregated to create the knowledge of a company, which is why, as part of normal compliance programs, they set up systems to be able to track and to spot when one of these prescribed catch-all controls, as they're called in the US, might implicate even for a non-US shipper. Does that answer your question?
Yeah, that's great.
Okay.
That's good. Thank you.
Nelson?
Sure. So Sam, as to the first question about what small and medium-sized enterprises can do to satisfy some of these requirements, the first line of defense is probably to have a clear code of conduct for your suppliers. This is a relatively inexpensive thing to do. There are dozens, if not hundreds, of examples on the internet of companies that have supplier codes of conduct that lay out the expectations when you go out to the market of what you expect them to do in terms of supplying. That is to say, they will not use convict labor, they will not use child labor, they will not use forced labor, they will not use toxic or hazardous materials, and so on. I mean, there's a whole litany of things that you want to use to protect your supply chain. So if you generate that code of conduct and you issue it and you make sure that your suppliers adhere to that and have some written record that they have read that and understand it and their expectations, that's your first line of defense. Second line is probably terms and conditions of purchase, when you have an actual contractual commitment of some kind to buy the goods that your buyer T's and C's, as we say in the United States, have some provision back to the code of conduct, and also any other export control or import control concerns can be reflected that way. Third layer is probably a reasonable level of due diligence. I mean, we have oddball situations. Kevin and I have both faced this over the years, where you do a simple Google search on the address of the nominal supplier, and you end up going to Zoom and finding out, or I mean not Zoom, Google, and finding that it's a home in a residential neighborhood or it's an apartment block, and it can't possibly be a factory that is supposed to be manufacturing these goods. So you need to do at least a minimal level of due diligence, sort of common sense checking, that if you can see that they don't really have a factory, then something is wrong. And if you can see it, certainly Customs and Border Protection is going to be able to see it. So you want to do some common sense checking, rely on trusted advisors and representatives, due diligence agents, scouts, find some reason to go out to the factory or to have your agent go out to the factory and look around and come back with a reasonable report. Build your record that you've done a kind of know your supplier check and document it. And I think if you've taken those steps in good faith, the way Kevin suggested a moment ago on the export side, you're probably 99%, even if something bad goes awry, the Customs and Border Protection people are going to understand and realize that you did what you could and something slipped by, but at least you had safeguards up. I think CBP is much more unforgiving if you've taken no measures and have no record to defend what you did.
Thanks. That's some great practical advice. Patrick, Calgary, quantum computing, AI, that sounds like stuff that's a potential issue out here.
Yeah, absolutely. There is a question of intellectual property and its movement around, of course. That's always keen for us. One of the things that I'm really interested in is the continuing of trade moving into foreign direct investment. And we've seen work between the Investment Canada Act and CFIUS. And of course, US Treasury Secretary Janet Yellen talking about friendshoring. We're in the game not only of trade, but foreign direct investment promotion. And I'm curious as to whether friendshoring is an established policy or what it would roll out and what the impact would be to Canadian jurisdictions who are attracting companies from abroad. And you know, a special note, you know, the Defense Production Sharing Agreement was just invoked not long ago by President Biden, and the potential of the US military actually financing companies in Canada in the way of mining. And I just wondered if it extended beyond mining as well.
Yeah, I'll get philosophical and bring it down, and Nelson can get more into the weeds if he wants. So the friendshoring is not like an official policy or a defined term. It really is a reflection of a Biden administration concept that our policy that comparative advantage is not really and shouldn't really be the animating force for trade. That is, that there should be free trade generally, and things should be made in the place where it's more efficient. And you know, these concepts that have been around in economics 101 textbooks for hundreds of years. And the reason for that was that shift. One, it's the sort of neoliberal economic philosophy of the Biden economic team in the White House that has what they call sort of a worker-centered trade policy, and a race to the bottom of the lowest, cheapest, most environmentally unfriendly, labor unfriendly kind of production anywhere in the world, which has dominated, you know, production for the last several decades. You know, really since the end of the Cold War, as a way in which is showing that our system is better than the Soviet system, is really disfavored by all the senior officials within the Biden team, USTR at Treasury, certainly at the White House, a little bit less so, but not completely at the Commerce Department. And so, and then that neoliberal philosophy really took a shock during COVID, and the realization that as a country, we were really quite dependent upon sources of supply in China. And you know, we weren't getting masks and incubators and medical equipment and pharmaceutical items. And oh my God, what would happen if there were ever hostilities even more severe than this? And our country would stop functioning because we were dependent upon China for so much input. And so then the friendshoring word started being used more often, and the government officials, the cabinet, have made it clear that it's not about making everything in the United States. They're very explicit. This is not about autarky, but things that upon which our economy needs, our critical infrastructure needs to survive to the extent humanly possible, particularly on critical items like semiconductors. We need to not be dependent upon China, and we need to be dependent upon either domestic manufacturing or, here's where Canada comes in, our friends, and that's the friendshoring concept. So although that word is, I don't think in any regulation, that's really a reflection of what it means. Now, how it actually sort of pans out day to day is really squishy, and I'm not quite sure what it means. And we've got you know, very harmonized CFIUS policies and foreign direct investment into the U.S. and you know, obviously investments from Canadian by Canadians will almost always be approved unless there's some significant third-party involvement of China or Russia or another country of concern. And there is a discussion in the U.S. about outbound investment controls, which would, and this is a very hot topic since the beginning of the Biden administration, of if basic philosophy is that if you can't invest or if you can't export technology for the development of AI or quantum or supercomputer or advanced node semiconductors, US dollars shouldn't be allowed to invest in the indigenous development of that same capability using foreign technology. And there's almost certain to be an executive order issued here soon that will, at a minimum, impose notification requirements on US investment into China in key sectors, and maybe some blocks in some of the key sectors in China. That's still being discussed, according to the media. But I can't imagine it would have any negative impact on trade or investment by or among or involving Canada. And in fact, this broader friendshoring concept, I can only imagine, would be of benefit to the bilateral. The biggest issue is with the Inflation Reduction Act and some of the other Buy American kind of concepts. I think sort of inadvertently, the administration and Congress have walled off and pissed off, frankly, all of our allies. And I think the administration gets that message, and that, for example, in buying electric vehicles, prohibiting vehicles coming in with batteries made in China actually can have a significant impact on our Canadian and Korean and Japanese friends. And I think they're working to address that. So I know that's a fairly top level policy set of commentary. Does that help with your question, or did I ramble?
And no, it's a value to get that background on it for sure, because we're out in the international marketplace talking to companies around the world and trying to establish, what the value is of the nearshoring side and where we should be, I guess, very cautious.
Yeah. Anyway,
thank you,
Nelson. Anything else to add?
Sure, I'll add a couple of additional points. First, the United States Congress passed something called the Foreign Investment Risk Review Modernization Act, or FIRMA, in 2018. One of the little noted parts of FIRMA was to authorize the CFIUS personnel to be much more forthcoming in sharing intelligence with allied nations such as Canada. So my guess is that US Treasury Department officials and people at the CIA and at Kevin's old agency, the Department of Commerce, are actively in contact with their counterparts in Ottawa these days, talking about perceived risks of certain foreign companies and certain foreign countries that are deemed of higher risk profile. And so this will cause inevitably probably more of the resistance and friction in Canada against investments that are coming from other nations. In the most recent survey that I've seen from the Rhodium Group in New York City, Chinese foreign direct investment into the United States from 2018 peak to the current time over the last 5 years has fallen somewhere between 85 and 90%, partly because of internal foreign exchange controls, partly because of COVID, partly because of these enhanced reviews that CFIUS is doing in the United States. But it's also the case that that kind of drop is causing Chinese investors to look for investment opportunities in other nations, not least of which is Canada. Mm-hmm. And so it's important for Canadian companies to think through the pluses and minuses of Chinese FDI, because Chinese owned and controlled companies will still be viewed as not Canadian companies, but they'll be viewed as Chinese companies within the parlance of the CFIUS review rules. So if they're continuing to sell in the United States, they continue to own, say, mining properties in the United States and so forth, then they'll be treated as Chinese companies, not as Canadian companies. And so Canadian managers and investors who are sort of thinking through, their long-term moves from an economic standpoint need to take that into consideration. It's even if Canadian authorities allow the deal to go through under Canadian foreign investment laws, what happens to the business of that company if it tries to go south of the border and is picked up on the US radar as essentially a Chinese controlled company. And this is all the more so in the case of state-owned enterprises in China coming in to the Canadian market to invest and buy and create. And increasingly, this is going beyond FDI into an existing Canadian or American business and even greenfield investments are being affected. Some of you, particularly in Western Canada, may have watched the debacle of the milling operation that was supposed to go into Grand Forks, North Dakota, and just completely melted down because of security concerns in that state and from the U.S. Air Force about such a large facility being located near, strategic Air Force bases, missile bases in North Dakota. So these are things that make management of FDI and investment more complex than it used to be, for sure.
Great, thank you very much.
Okay. To Winnipeg, Andre, you've got defense industries. If anyone in Western Canada does, it's you.
Thanks, Carlo, and thanks, Nelson and Kevin. Great insight. Really appreciate. I guess my question, and you spoke earlier about how things seem to, some policies can come in place pretty quickly, et cetera. Is there anything that you're hearing, without asking you to look into the future, but are there any discussions happening? Anything like, I know companies will say, okay, as things evolve, how do we prepare for the future too? Are there other things that are being discussed, other elements that perhaps companies, exporters should be immediately concerned about that perhaps are not an immediate concern for the next 6 months, but maybe down the road? Are there any elements like that, as you guys are obviously watching this very closely, any discussions happening at US government levels, et cetera, that policies that may come down the road that could affect Canadian exporters down the road?
So in both the PowerPoint and my prepared remarks from this morning's Senate Banking Committee testimony, I give links to a speech the National Security Advisor Jake Sullivan gave last September. And this is really a sort of the core of my historical background and context to what I reported, which is the evolution of export controls as a policy matter in the US beyond just those items that have much more of a direct relationship to the development, production, or use of weapons of mass destruction or conventional weapons into a strategic trade tool. And in that speech, he cited 3 technology areas, this is answering your question, that are, as he referred to it, as force multiplying technologies or enabling technologies, meaning even though they're inherently commercial, they're not directly related to the military thingy, they are nonetheless what is needed for a country, for an ecosystem to be able to function. And on the Russia side, it's really being defined, particularly since the Friday rules were announced, looking through the other, turning the telescope around, and basically anything the Russian government needs to keep its vehicles and other equipment up and running, whatever commercial items the US and the allies, Canadians, UK, Europe, are all looking to shut down. So on the Russia side, which I suspect most of your companies have largely pulled out anyway, it's a fairly expansive list of items that historically are not controlled, and that's being driven, in terms of, to answer your question, by whatever Russia needs to keep the military functioning. That's going to get cut off. On the China side, although it wasn't really about China, it was really about China, it's 3 technology sectors. So it's the advanced compute, which the October rule I referred to is key. So anything involving advanced node semiconductors or supercomputers or AI applications, and I'll get to that in a minute. And then the other 2 topics are biotech and bioengineering and clean energy tech. Now, he didn't go through and articulate that there would be new export controls in biotech or clean energy. In fact, he said nothing. In fact, the only thing he did say, though, was on the industrials policy, which used to be a bad word in the US, but now is actually sort of the hot topic. I mean, literally today, the US just announced the process by which companies, US and foreign, can submit to get money in order to do more advanced, more development or production of semiconductors in the United States. And so those 3 areas, advanced compute, as I described it, biotech, bioengineering, still kind of squishy where it's headed, mostly on the industrial policy, probably some on the human rights side, and then clean energy, which is probably going to be with respect to electric vehicles and batteries and that topic. But whether it translates into export controls is still a big unknown.
So my final response to you, Andre, would be sort of in 2 tiers. At the macro tier, I would say keep an eye on what happens with China's response to the war in Russia over the next few months. It is no accident that Secretary of State Blinken and others have been saying very overtly, very publicly, about their conversations with senior diplomat Wang Yi in China, particularly at the Munich conference, that it would be a tragic mistake for U.S.-China relations if China were to furnish lethal aid to Russia at this juncture in the war. If that is detected, the U.S. will undoubtedly impose far more punitive sanctions and economic sanctions and export controls targeting Chinese companies, and that will almost certainly have ripple effects on third countries such as Canada. You know, there is some truth to that. When elephants stampede, the grass get trampled, you know, so just be thoughtful of the news headlines and where that is going, because that will completely change the landscape for economic relations between the United States and China, and therefore our attitudes toward goods made with Chinese inputs, or on Kevin's side of the ledger, exports of American technology flowing through third countries onward to China. On a more micro level, it's also important for both of these kinds of regimes, but particularly in Kevin's case in the export control area, to keep an eye on an announced policy of the Canadian government. In Ottawa, Immigration, Refugee, and Citizenship has announced a very ambitious, bold vision to add 500,000 foreign workers to the Canadian workforce over the next several years. And there are special programs all across Canada that provide kind of a fast track to a postgraduate work permit and other avenues like that to accelerate residency. And so as a consequence, Canada is becoming a great magnet for foreign workers. But unless and until they achieve permanent residency in Canada, those individuals continue to be treated for US law purposes as individuals of those nations whose passports they carry. So if you attract an Iranian worker through these things, studying it at the University of Toronto or the University of Winnipeg or, you know, whatever, you know, University of British Columbia, you know, and you hire them and they're a great engineer, they're great scientists, whatever, you know, you run some risk that if you're using sensitive, controlled American technology in your company and you need that, then these tightening export control rules will suggest that the Bureau of Industry and Security could take issue with that hire. And so that's bumped into Canadian human rights laws in the past, but these are realities right now. And so companies need to be very thoughtful about managing the changing domestic Canadian workforce, which is going to have, I think, a much higher percentage of foreign-born workers than it has historically had. And so your factories, your laboratories, your universities are going to be filled with many more diverse people. And it happens that China and India and other places like that do send many, many students into your universities and therefore into your workforce. And that will have legal ramifications for the rules that Kevin and I have been discussing today.
Thank you very much.
Yeah, we've seen that with sending workers across the border and foreign nationals in Canada getting stuck at the border. Chris, we'll take the last question over to you. I think we may have lost Kevin, but Nelson's more than capable of handling anything that comes his way.
I'll say Kevin should have answered that.
Thank you, Carlo, and thank you to the Canada West Foundation for this opportunity, and to Kevin and Nelson for their presentations and valuable insight on U.S. export control initiatives. Lots of questions. Some have been asked. The usual process for addressing border issues with the U.S. is through trade dispute panels, either through NAFTA 2.0 or WTO. That's unfortunate for two reasons. One being the first, that it's extraordinary length of time that it takes to hear disputes and rulings to be issued, but also because of the US's growing lack of commitment specifically to the WTO and their use of national security as the reason for all things trade. So I suspect the train has left the station on this particular issue. I don't think anything that the federal government can or will do will make much changes. So my question is very specific. What are the enforcement provisions or mechanisms that are available to the US should and might they find an industry or a company that might be in contravention of these US export control initiatives?
Well, first of all, let me disagree slightly. I think the Biden administration and its U.S. trade representative are very much committed to the WTO process. I think much of the conversation that the economic policy team and the international relations teams in this administration have been focused on defending and strengthening established rule sets like the WTO, like the World Bank, like the United Nations, and so on, and defending that against those that would challenge those established rules that have sort of set the guardrails since the end of World War II. There is more suspicion and opposition, I think, in Congress. That's one of the reasons that the United States did not follow through and join the Trans-Pacific Partnership, which Canada and other major players in the Indo-Pacific have continued on their own. It is the reason that strategically the administration has not tried to revive TPP and instead has substituted this Indo-Pacific economic framework as a kind of TPP light version, which doesn't have this either the teeth or the security of TPP, but also does not have to be ratified by the U.S. Congress. And that's been the sticking point for these kind of formal agreements. We have a very populist spirit in the United States right now that is making it very hard to follow through on these traditional commitments to things like bilateral dispute resolution, which was the beginning of your question. But I think the fact that we were able to get through the U.S., Canada, Mexico agreement, during the Trump era, is a sign that, in the right package, things can still be done. And my guess is that that's what will have to be done. It will have to be very opportunistic, and will not be a broad-based grab everybody and have a kumbaya movement, but instead there'll be these very selective packages put together that have a hope of being supported.
Nelson, let me conclude by asking you this. There are two ways to deal with extraterritoriality from the U.S. One is to internalize the U.S. procedures, align with the U.S. rules, adopt U.S. laws in Canada, or move Canadian laws to fit new U.S. rules. The other way is to try to provide protection for Canadian businesses, indemnify them against harm or actions from the U.S. We did this in the 1980s and the 1990s, the Foreign Extraterritorial Measures Act, and we had rules in 1990, 92, 96, preventing Canadian companies from complying with Helms-Burton regulations and requests from the U.S., ordering Canadian companies not to comply on the subject of being fined by the Canadian government. We had prison sentences on the books for complying with U.S. Helms-Burton rules. It looks like that's not an issue today because we're aligning with the U.S. But would any of those measures that we adopted in the past work with the new U.S. rules to protect Canadian business owners or to protect Canadian businesses, clawback arrangements for fines in the U.S. and things like that. Would any of that be viable going forward? It doesn't look like we're going to do that in Canada, but should we come to loggerheads with the U.S., would any of that be viable?
Well, I'm not admitted to practice in any province in Canada, so I will defer to Canadian colleagues in the legal profession to answer the question of whether, the Foreign Extraterritorial Measures Act and things like that, would have any traction to deal with these programs. I think, I can say from the US perspective, the US government is well aware that Canada, Mexico, the European Union, a number of other countries have taken those kinds of measures in an effort to avoid encroachment by US laws on their sovereignty and the ability of their companies to do business as they see fit. Generally speaking, the US enforcement agencies have very little sympathy for companies that are caught in the middle between, do you want to be shot in the left ear or the right ear? They say, too bad, the law is the law. And that's the way they look at it. So I don't know that US agencies are deeply moved or much persuaded by those kinds of laws, whether in the European Union or in Mexico or in Canada. I think, companies that are caught in that in-between space usually just act very prudently and try not to provoke situations where it increases the likelihood of a junction between those two rule sets, that is Canadian law and US law, and just try very hard not to go into that space to create, that creates the conflict.
Well, it seems like in the past, we got away with a bit more because it was Cuba. And depending on the administration in the US, if there were Cuban hardliners in the Republican administration, we had to play it a little more carefully. If it was Democrats who were a bit more open, we had more latitude. But with China, that's off the table. I don't see us getting any of that latitude that we had in the past.
Well, partly I think that is so, but I think it's partly also that the Canadian government, if you read their new position papers on the Indo-Pacific and their own assessment of the security risk, in the Indo-Pacific environment, which may have been covered in yesterday's, panel. I think the Canadian government itself is looking differently at the geopolitical and security situation in the Indo-Pacific. I think you got a flavor of that in British Columbia when you saw Ms. Meng being arrested and being held by the mounted police on charges stemming from an indictment in the United States and the controversy that created with the two Michaels and so on, in Canada. It is really, these are very high stakes times for national governments in the Indo-Pacific. And I think everybody is reassessing right now all the way across the arc of the Pacific. Certainly, I was in a program last week with the ambassador to the United States from Australia, and he was talking about how the Australian government has been reassessing its own economic and geopolitical situation in the Pacific. And I think this is just part of the evolution and the so-called interesting times we live in.
Okay, well, folks, we're over time. Does anyone have a last burning question? Okay, we're all going to be good, polite Canadians here. Wonderful. So, Nelson, thank you. We'll thank Kevin Wolf as well. And again, we thank Export Development Canada for the support to have this series. Mark Livingston's the Vice President for Western Canada. We'd like to thank him in particular. And of course, our partners across the prairies. Andre Brin, World Trade Center Winnipeg, Patrick Madarin here in Calgary at Calgary Economic Development. Next door, Chris Decker at Saskatchewan Trade Export Partnership. Manisha Aurora, just up the QE2 in Edmonton at Edmonton Global, and special guest Sam Woods, customs broker here in Calgary at Joy International. Thank you one and all, and until next year, we'll see you guys for whatever sitting out there on the horizon waiting for us in 2024. Have a good
I
day.
may be
everybody.
dating myself, Carlo, but in reference to an old television series that was once very popular in the United States called the Hill Street Blues, the going away line was always, be careful out there.
Thank you very much, everyone.
Good advice to leave on. Thank you.